guys, it's Kathy. I hope you're doing well. We made it to Friday. Wow, what a week. And it doesn't matter. I don't have sound, but I know you guys do for the video. So I'm just going to play it, listen on my phone, which means I have I don't know, 11-second delay. So if there's an issue, I won't know for 11 seconds. You can't hear me? I'm going to. Oh, I see. Hold on, hold on.
call it a trial readiness. Clay's not here on the 3rd of August. How about August 3rd at 9 a.m.?
That works.
Okay. And then I'll reserve time on July the 6th. What did I say?
Right?
What did I say, 9 or 10? 10?
You said 9, but we can
We'll
go
do it at
to
9, that's fine. In case, if you file something, you know, we can hear it then or just treat it as a status or whatever. Maybe you'll do a change of plea that day. I don't know. So what I've done, Mr. Blackman, is set you up for some hearing dates. We'll have you back on July the 6th at 9 a.m. for a status or to consider bond upon your counsel's motion. August 3rd at 9, that's a trial readiness. September 14th at 10 for a pretrial conference. And October the 13th, 14th, and 15th is a trial by jury. Those will start at 9 in the morning. If you don't appear for your jury trial on October the 13th, we'll hold it in your absence. You can be convicted even if you're not present. Okay?
Thanks, Judge.
Have any questions, Mr. Blackman?
Joe Clement was asking me about the today if they take the 2,500, they'll let me out because I had a warrant out of Lake County where the same issue I had to address.
Your attorney eloquently argued for your bond, but until I have that motion in writing, I'm not going to consider it, sir.
Oh yes, sir.
So I set you for a jury trial. What I'm looking for is an affirmation from you that you understand. I set a jury trial in your case on October the 13th. And if you fail to appear for that jury trial, I'll hold it in your absence and you can be convicted even if you're not present. Do you understand that?
Yes, sir.
Okay, thank you. We'll see you back here July the 6th at 9 a.m. You're ordered to appear.
Thank you, Judge.
Thank you, sir.
Yeah, I'll give it to BA too to see what theirs.
Matthew Coxey, state, would you please set our record?
This is Matthew Coxey, 64D01, 2509F310119, and 64D01, 2510 CM12154. Defendant is present by video at the Porter County Jail and is represented by counsel attorney Patton. State's represented by Deputy Prosecutor Hammer. I believe we had set him for competency, which I believe we received the last time we were in at least one of the evaluations.
I'm Judge Mike Fish. Welcome to Porter Superior Court 1. This is our Monday morning high-level felony call. If you're in court for some reason other than a level 5 or above felony, you are in the wrong place. You should talk to security about how they can redirect you. You can get started with Anthony Blackman. State, would you please set our record?
Yes, this will be State of Indiana versus Anthony Blackman, 64D01, 2412F513224. Defendant is present with it by video in custody at the Porter County Jail and present by counsel attorney Clement. State is represented by Deputy Prosecutor Hammer. We were set today for status.
Good morning, sir.
Good morning.
Mr. Blackman, can you hear us okay?
Yes, sir.
How can I help, sir?
Well, you know, when we were here last time, we talked about trying to resolve the case. Oh, sure.
Just pull the whole thing over towards yourself. There you go.
When we were in here about a month ago or so, we talked about trying to resolve the case. We haven't really had that opportunity yet. I would like to see him released on his previous bond. He's got a bond of $2,500, Judge, and the reality is the only court date he missed was the one when he was in custody, I believe in Illinois, and he missed a date back in October, and that's when a warrant was issued. But aside from that, he's always.
Hi guys, it's Kathy. I hope you're doing well. We made it to Friday. I don't know if you can hear me. It looks like you should be able to, but it did before. So, anybody hear me? Alright, I'm going to play the video now.
He's made all of his court appearances. And the only other thing I would say that even when he's released on this warrant, or he's got to go to Lake County because there's an outstanding warrant in Lake County. As you recall, he got arrested on the same night in Lake County and Porter County because he was right on County Line Road. So there's two cases arising out of kind of similar facts. So again, once he takes care of this case, or if you release him, he's got to go to Lake County and we got to address the warrant over there. He has no other warrants anywhere else. Everything else is resolved. It's just these two cases, which came about in December of 24.
Yeah, if you're gonna try to modify bond, you need to file that in writing, counsel.
Okay. You won't agree to it?
Not today.
Would you respond to my emails?
Yeah, I was preparing for trial. I'm sorry.
Well, maybe an email that says that would help. Sorry, Judge. Okay, I'll file
Yeah,
something.
I'm not gonna consider a motion to reduce bond.
I didn't want to reduce it. I just wanted that bond to be reinstated as his bond. Because again, he's not missed any court dates except for the one when he was in custody in Illinois.
Oh, I see. There was a revocation of bond back on May 7th. Yeah, if you wanted to anything to change his status of release from jail, including reinstating his previously posted bond, I would need to have that in writing.
Okay,
Yeah. Okay.
all right. You want to
So
give me?
what kind of continuance do you want? You want a week to get that on file? I'm in trial next week.
Sure.
2 weeks on the 29th?
Pardon me?
You want to do it on the 29th? I'm in trial next Monday.
No, I'm out on the 29th. I'm sorry.
Well, he's your client. The 6th of July?
That'll work.
Want to do it at 9?
Sure. So
Okay.
we're going to argue whether or not he can get out on bond, or you want me to file that with an order? I'm not sure. Or we're just doing a status on the 29th, whether he gets out or not. Is that what we're doing? On the 6th, I'm sorry, July 6th.
What do you want me to do, sir? It's your case. Hey, you ready to try this case?
Pardon me?
Yes, sir.
When do you want to get it on the trial calendar? How many days do you need?
Probably 3.
You want to set it for trial? Is that what we're doing?
Yeah, we'll set it for trial, and then if you file a motion, I'll hear it on July the 6th.
Okay.
When you're ready to try it, state.
I guess whenever the court has availability, Your Honor.
Josh, I'm going to answer that. You won't believe this. I live in Lancaster County. Okay, I don't live in Lancaster County anymore. I moved. Anyway, it doesn't matter. I'm still at Lancaster County. We are surrounded by trillions of cornfields. We have corn everywhere. So I'm trying to find corn seeds to plant. And no one's selling them. I can't find a freaking corn seed to save my life. And I refuse to order it online because I live in Lancaster, even though I moved from Lancaster. But no corn yet. I got every other vegetable. I got 30 packets of seeds right here ready to plant as soon as I get a day off. No corn.
Do it on October 13th.
Good on my calendar.
Any problem, state? Other
No, Your Honor.
Did add
I mean-
after that?
Yeah, apart from, I think we have McKay the week prior and Trinidad the week after, but I'll make it work.
Oh no. It looks like because I paused it. Oh, I thought I lost sound again. I'm sorry. I'm pressing play. I'm sorry.
Okay. We'll do a pretrial conference on September the 14th, if you're available. Council,
I'm available,
9 or 10?
either one.
10 o'clock? And I'd like to touch base in August, see where things are. I call it a trial readiness. Clay's not here on the 3rd of August. How about August 3rd at 9 a.m.?
That works.
Okay. And then I'll reserve time on July the 6th. What did I say?
Right?
What did I say, 9 or 10? 10?
You said 9, but we can
We'll
go
do it at
with
9, that's fine. In case, if you file something, we can hear it then or just treat it as
Right.
status or whatever. Maybe you'll do a change of plea that day. I don't know. So what I've done, Mr. Blackman, is set you up for some hearing dates. We'll have you back on July the 6th at 9 a.m. for a status or to consider bond upon your council's motion. August 3rd at 9, that's a trial readiness. September 14th at 10 for a pretrial conference. And October the 13th, 14th, and 15th is a trial by jury. Those will start at 9 in the morning. If you don't appear for your jury trial on October the 13th, we'll hold it in your absence. You can be convicted even if you're not present. Okay?
Thanks, Judge.
Have any questions, Mr. Blackman?
He was Joe Clement was asking me about the today if they take the 2,500 they'll let me out because I had a warrant out of Lake County where the same issue I had to address.
Your attorney eloquently argued for your bond, but until I have that motion in writing, I'm not going to consider it, sir.
Oh yes,
So I set you for a jury trial. What I'm looking for is an affirmation from you that you understand. I set a jury trial in your case on October the 13th. And if you fail to appear for that jury trial, I'll hold it in your absence and you can be convicted even if you're not present. Do you understand that?
Yes, sir.
Okay, thank you. We'll see you back here July the 6th at 9 a.m. You're ordered to appear.
Thank you, Judge.
Thank you, sir.
Yeah, I'll give it to BA two to see what theirs.
Matthew Coxey, state would you please set our record?
State of Indiana versus Matthew Coxey, 64D01, 2509F310119, and 64D01, 2510 CM12154. Defendant is present by video at the Porter County Jail and is represented by counsel attorney Patton. State's represented by Deputy Prosecutor Hammer. I believe we had set him for competency, which I believe we received the last time we were in at least one of the evaluations for competency the last time we were in court.
I only have one.
I recall seeing two, but I can look through my file. I believe there was one from Dr. Spores dated April 30th and one from Dr. Copley dated May 18th.
The one from April 30th may have not made it into both files. Yep, I do see them both. Read them when they came in, but I don't recall. Okay, so competency is not a question. How would you like to proceed?
Your Honor, we have a proposed resolution which the defendant's considering. One of the components would have him residing with his grandparents out of county. So we're exploring that option further, if we could have a further status in 30 days or so.
July 13th
Thank you.
or 20th?
13th is fine.
Okay. All right, on defense motion, Mr. Coxey will set you over to July the 13th at 9 a.m. You're ordered to appear back here July the 13th at 9. Do you have any questions?
No, sir. Thank you.
Desmond Dupriest, state, would you please set our record?
This will be State of Indiana versus Desmond Dupriest, 64D01-2604F4 4600 and 64D01-2208F3 7222. Defendant appears in custody by video at the Porter County Jail and is represented by Counsel Attorney Patton. State's represented by Deputy Prosecutor Hammer. We were set today for status and also, I believe, on defendant's motion for bond.
So we have the omnibus hearing for short cause F4 4600. Is everything fine with the discovery there and everything on the omnibus?
We're still going through discovery. I believe the state was doing some testing on the handgun, and I'm not sure what the status of that testing is.
Okay. What's the status of that testing, sir?
Your Honor, as of Friday, when I checked again, it was still in progress as much as they're working on it, but I don't know. I told them the urgency.
Okay.
But they had only received the gun, I think, 2 weeks ago.
Okay. So I have a motion to reduce bond. Mr. Patton, would you like to present that?
Yes, Your Honor. The bond that was set by another court when the case was filed in the amount of $25,000 cash. I don't believe that this court has ever, or Your Honor has ever reviewed the bond amount. He's been in custody since April 22nd. He would be able to post a cash bond of $2,500, or if you converted the current bond to a surety bond to pay that $2,500 to a bondsman, he would reside with his partner and his child's mother in LaPorte and would resume his previous employment, full-time employment. So we would request that that bond be reduced and that any further orders that you impose with regards to pretrial services be imposed.
State?
Your Honor, the state still believes he's a danger to the community. I mean, he was out on probation for a very serious crime in F3 7222, and his criminal history throughout his life, he's come into contact with the juvenile authority since 11th. He was been adjudicated a delinquent of battery, criminal trespass. He's been arrested on 12 occasions with 7 misdemeanor and 2 felonies. And this is another one, 5 of which are battery related. He's had all sorts of probation, counseling, juvenile detention. And with this, Your Honor, in the commission of these crimes seem to be getting worse and nothing's changed. Again, this is another serious crime, a serious possession by a serious violent felon, and alteration, which is actually more concerning, Your Honor, which is the obliteration of marks on the gun, which is a serious crime. As state would be arguing still that the danger to the community is extremely high in this instance, as well as his history would also demonstrate his inability to maintain himself while out on bond or otherwise. So I believe the bond that was set was appropriate.
Your Honor, looking at his PSI from the older case, his adult history was a bunch of misdemeanors for driving offenses and marijuana and a theft. And then the one felony, he made the serious mistake of taking the law into his own hands and essentially beating someone up who had committed some sex crimes or someone that was close to Desmond. And he paid the price for that by going to prison. And now he's on probation for the suspended portion of that sentence. He's innocent until proven guilty of this new offense. And based on the discovery that we do have with the interview of the person that was found in the car with him there, I think there's serious questions as to Desmond's knowledge of the presence of the weapon in the vehicle. And And that's what the testing, I believe, is for with regards to DNA and fingerprints. He has significant ties to the community. He's not a flight risk, and would request that the bond be reduced in this matter.
Okay. Right. Yeah, I don't think the legislature feels like the.
You're right. I had no sympathy. None. But my body still hurts. Okay, see, it's not. Okay. I had 2 cars, right? But my son accidentally destroyed one of them. Alright? So now we have 1 car, and we moved an hour away, and I have to turn myself down because I hate my voice. Okay, see, it's not. Okay, so my daughter starts work at 8 a.m. I start work at 11:30, and my son sometimes starts work at 9, 10, sometimes 3 p.m. I live an hour away. So I can't drive to Lancaster and drop Tiffany off at work and then come home, because by the time I get home, I have to go right back out again. So then me and Tiff both get off at like 5 p.m., right? But Anthony doesn't get off work till like 9:30, 10:30, sometimes 11. He works in a restaurant, so it's different times. So we struggle getting back and forth. It's just I've been driving hours and hours and hours every day. Tiffany doesn't drive. We only have the 1 car. So, like last night, we left here at like 6:30, or as soon as the stream was over, and we didn't get back home till midnight. Because it wasn't worth it coming the whole way back home just to drive the whole way back out there again. Gas is pretty freaking expensive. Although I did find gas for $3.49 yesterday. Well, because I'm not home as much as I want to be, nothing's getting done. I got home at midnight, and my stream supposedly started at 4:30. But it didn't, because I had all those issues. So I haven't been able to stop and sit and rest. I haven't been able to enjoy my new house. I haven't been able to do anything, because every day I gotta drive for hours, and then I gotta work, and then I gotta come home and try to get something done. So it's been crazy. So I rented a room. I got a room for us. I don't have it yet. She said yes yesterday. I don't have it yet in Lancaster. So now we can all leave in the morning and go to Lancaster, and whoever's working can go to work, and we can stay in the room until we have to go to work. And it's been a crazy week. You guys don't even know. I have not seen what we're watching today. I was gone all day yesterday, so I just picked Judge Fish because we like Judge Fish. I don't know what happens, but I'll tell you one thing. He needs to be let out of jail. I think this is a joke. Don't do it. But we should all give him money on his commissary, on his books. Don't do that. Don't ever reach out to any of these people. But because he's a hero. He went to jail for beating up a bad person. And I think bad people should get beat up, and bad cats should get stomped. Bren, I didn't stomp them yet, but man, they're working on my nerves. All right, Judge Fish. This is from the 15th, from right before I moved. And I picked this docket because today's docket was only 50 minutes long. And I don't know if that included any pauses. So we went back in time to Judge Fish. I love Judge Fish. Oh, and Josh. I know people said he was about to get deployed, but I don't think they hurt me. Why are you all capsing that? They hurt me. I'm the abused person in this relationship. These cats don't care about me at all. Not even a little. If I was lying on the floor bleeding, they would ask me for food. Anyway, he just got off deployment not too long ago. So I don't know where it said he was getting deployed. But I don't know if they stomp on me. All these cats are gonna make me lose my mind. They don't. I have these outlets in this house. They look brand new, but the cords do not stay in the outlets. Yes, I pinched them. Yes, I pinched the cord. I did. The plug. I pinched it so it's supposedly tighter. But if the cat jumps on it, it falls right out. And my cord for my computer is way back where they don't need to go. But they keep knocking my power out on my computer. So I'm working, and boom, there goes the power in my computer. I think they do it on purpose now because they want to hear me swear. Maybe they think it's praise. I don't know. Oh, I chose this. I chose these cats. I did not choose these cats. I was cat free. I had no cats. And then my niece brought over this cat that it fit in the palm of your hand. It was like half dead. Almost all of its fur was gone. That was crazy because we found out 2 weeks later it was ringworm. And we got the cat treated, and then we got all of us treated. The cat was pregnant. Cat had babies. And then my daughter came over. She had cats. They also had babies, and we had so many cats. I didn't choose these cats, but I do take care of these cats, and then they abuse me for it. Look, they're running around right now making a noise, abusing me for it. But they need to stay away from. I'm gonna duct tape all of my plugs into my outlets. That's what I'm gonna do. Thank you, Jude. See, me and Jude understand. I'm just gonna duct tape everything. I have no bedroom door right now. It's over there. The door is over there, but it's not hooked up, or it's not. There's no hardware in the wall right now. I know that's a simple fix. I just haven't had time to hang a door in my room, so I can't lock the cats out, so that I can stream without any issues. She is under the bed because the orange cats did not take the move well. They are unhappy. They're very mad that they have to be in this house right now. Even though they have everything provided for them. Toys, treats, food, water, many litter boxes to choose from, with many different scent litters. I know I don't have the glitter litter. I should get that, but I don't. No, but apparently they're traumatized. So she is under the bed, right beside me. She'll come out when she's hungry, and then she'll meow at me, and be mad, and then she'll go back under the bed. She just needs more time. I don't even know what to say about Orange Cat's bread. I think she might be under the bed right now because the other cat is borrowing the one brain cell they share together. And that cat hasn't left my side. She's on my bed right now, won't leave. She's just on my bed. Anyway, I don't get those orange cats. I don't understand. But they're not the problems. They don't run around and knock my cords out. No. It's the other ones. There's two. Lafayette and Luna. They just chase each other all day, all night, up and down, up and down, up and down, and knock all the cords out. And they both are jumpers. So they'll run to the doorway and jump across the room and bam, right on me on the bed. Even if I'm sleeping. And I don't stomp on them, I just swear at them. And you're allowed to swear at cats. There's no rule anywhere that says you can't swear at cats. Hi, Zach. Kelly, I'm so sorry. I'm so sorry, Kelly. I'm so sorry. Earlier, you sent me a super chat, and I did not thank you. I was in the middle of something. Thank you so much. Zach, you just got Snoop. Snoopy. You just got a membership. I got to do a marathon for members. Oh, no, a marathon. Just a regular marathon. I have off today. I have a lot of work to do today. But I'm going to sleep. Then I'm going to try to get my green screen up. Then I'm going to try to get a marathon together. That's the plan. Alright, I just went off on a tangent. I'm going to press play. I swear at everyone. I've swore at every single person in this chat at least once. Except for you, Walter. Walter, I would never swear at you. Alright, press play.
Operation of a firearm is the more serious offense here. He's charged with a level 4 felony unlawful possession of a firearm, which is certainly the higher and more significant charge. I typically don't set $25,000 bond in a level 4. So I'm happy to grant the motion to reduce the bond. We'll go down to $8,000 on it, but I'm going to hold him without bond on the probation revocation. So I don't know what good that does for you. I feel like the probation revocation, even though the first revocation wasn't as serious a matter, we're on the second addendum to the second revocation. And the second addendum also marijuana use, but the second addendum to the second petition deals with this charge and the possession of a firearm. So we'll hold them without bond on the revocation matter. I'm happy to set that revocation matter for a final hearing.
Yeah, and I think
I should do.
Yeah, and I think the matters are so intertwined with the new case. We would just request that the previously set court dates of July 13th and August 10th be confirmed.
Okay. Yeah, Mr. DePriest, so I granted the motion to reduce your bond, but I'm also holding you without bond in the F37222 case. I already had an omnibus hearing set for July the 13th. Yeah, I guess today wasn't even the omnibus, so I misspoke earlier about the omnibus setting. And then a pretrial conference on August the 10th at 9 a.m. You're ordered to appear for both of those. We're adjourned.
Thank you, Your Honor.
Good day. Angelina Gottschlich, stay, would you please set a record?
This is State of Indiana versus Angelica Gottschlich, 64D01 2511 F412368. Defendant appears in custody by video at the Porter County Jail and is represented by counsel. Attorney Patton States represented by Deputy Prosecutor Hammer. We were set today for status, Your Honor.
Yeah, I don't know why I called you Angelina. My bad. Mr. Patton?
Your Honor, we're still in discussions if we could have a further status date in July.
Do you want to use that 13th?
Sure.
Okay. Yeah, Ms. Gottschlich, we'll have you back on defense motion on July the 13th at 9 a.m. You're ordered to appear back here July the 13th at 9, delays charged to the defendant. We heard from Mr. Fleming. Jamal Woodley, state, would you please set a record?
Yes, this will be State of Indiana versus Jamal Woodley, 64D01 2603 F5 2736, 64D01 2601 CM710, 64D01 2510 F6 11542, 64D01-2506F4 6024, and 64D01-2407 CM 7760. Defendant appears in custody by video at the Porter County Jail and is represented by counsel. Attorney Patton in the courtroom, states represented by Deputy Prosecutor Hammer. We were set today as a status on these matters.
Mr. Woodley, can you hear us okay?
Yes, sir.
Counsel, how can I help?
You know, we're still in discussions with the state. I need to speak with Mr. Hammer once again. If we could have a further date, if the 16th of July is not getting too full.
Any objection, State?
No, Your Honor.
July 13th, Mr. Woodley at 9 a.m. We'll have you back July the 13th at 9 on defense motion. Delay charge to the defendant. We'll see you then. Eric Wilson, State, would you please set a record?
Yes, Your Honor. This will be State of Indiana versus Eric Wilson, 64 D01 2108 F4 7159. Defendant appears in custody by video at the Porter County Jail and is represented by counsel. Attorney Patton in the courtroom. State is represented by Deputy Prosecutor Hammer. We're set for status.
Mr. Wilson, is that a religious head covering?
Yes, sir.
Sir, please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, sir.
Okay, thank you. I have a one-page document entitled Agreement and Waiver of Right to Appear in Open Court for Hearing, which appears to bear your signature. Did you sign this document?
Yes, sir.
Understand you're waiving your right to appear personally here in court today. You're appearing by video instead?
Yes, sir.
Thank you, sir. Then I have a one-pager here entitled Recommendation of Disposition, which appears to bear your signature down along the left-hand side. Do you recall signing this one?
Yes, sir.
This one says that you plan to admit to violating your probation, and then upon so doing, you'd be sentenced to 544 days in the Indiana Department of Correction with none suspended, credit for time served. You'll be terminated and released unsatisfactorily from probation. Fines, fees, and costs would be entered as judgment liens. Is that your understanding of a proposed disposition here?
Yes, sir.
Realize that if you admit your probation violation, that you'll be waiving the right to a hearing where the state would have to prove by a preponderance of the evidence that you actually violated your probation.
Yes, sir.
You'd be waiving the right to confront and cross-examine witnesses, and if necessary, use the court's subpoena powers to have witnesses brought here to testify on your behalf.
Yes, sir.
And with that in place, sir, you still want to admit here?
Yes, sir.
All right. So this says that you violated Rule 11 for laws and conduct, and it suggests that you were arrested or charged with possession of a stolen vehicle in Chicago in November 2024. Is that what you plan to admit today?
Yes, sir.
Is there a disposition on that case?
Yes, Your Honor. He served his time in Illinois.
You ultimately were found guilty of that charge, sir, or one related to it?
Yes, sir.
Okay. Court will accept your admission, find that you violated your probation, accept the recommendation of disposition, and sentence you in accordance with the terms of your agreement. Good luck to you, sir.
All right.
Your Honor, do we know how many credit days he's got?
Yes.
I
Your
don't,
Honor.
but we're gonna get into it.
The bench warrant was served April 17th of 26, and through today through the 15th, today would be 61 days.
So we think that there is credit time from April 17th, 2026 through today, although we don't include today. But is it still 61 if you don't include today?
Yes, Your Honor. It would be 60.
60 days. Is that good, Jail?
Yep, thank you, Your Honor.
William Messer, State, would you please set a record?
Yes, this will be State of Indiana versus William Messer, 64 D01 2308 F4 7554, and 64 D01 2304 F6 3459. Defendant appears in custody by video at the Porter County Jail and is represented by counsel. Attorney Patton in the courtroom. State is represented by Deputy Prosecutor Hammer. We were set for sentencing.
Anything on the pre-sentence report, Mr. Deputy Prosecutor?
No, Your Honor.
Mr. Patton?
Your Honor, we have reviewed it. I guess, once again, I'll take issue with the probation department not knowing how to contact Mr. Hammer or myself because it appears there was confusion where it says at the end on page 13 that the plea agreement does not directly address short cost 3459. It says on the change of plea order that all remaining counts and causes will be dismissed. So I'm not sure why that is not clear to probation, and I'm not sure why they don't just pick up the phone or send an email to Mr. Hammer or me. But I just want to clarify that that short cause is being dismissed with this plea.
Fair enough. I see it right there.
William, have you reviewed the document I delivered to you late last week, and do you have any corrections to it?
No, I reviewed it.
State evidence or argument for sentencing?
Your Honor, I would just ask that you accept it, given the circumstances and everything going on. I believe this addresses all the issues.
I mean, Mr. Patton, even the top line of subsection 10 supports your assertion.
Again, if there's any ever confusion with the plea agreement, I invite the probation department, if they don't want to contact the defense attorney, contact the prosecutor,
Yeah, I understand.
ask the question.
I understand. Evidence or argument for sentencing, sir?
He has completed the CDA program a few weeks ago. We would just ask the court to accept the plea.
Okay. Master, sorry I couldn't make it out for your CDA graduation. Hopefully you got significant benefit from that program.
Yes, sir, I did.
This is your chance to say whatever you might like to say before I rule on the case. Would you like to exercise that right, sir?
Just appreciate you accepting the plea that they came up with me. I appreciate it. You accepted it. I know everything with the drugs. It was just a bad situation that had happened. Not like that.
All right, sir. Anything else? I can't really hear you if you could project your voice a little bit more.
Yeah, that's it.
Okay. Well, at this time, the court will accept the recommendation of plea negotiation. Pursuant to that, enter judgment of conviction on a lesser included count 1 in F4 7554, dealing a controlled substance, a level 5 felony, dismissing all the remaining in F4 7554 and dismissing the charges in F6 3459. Sentence you to 1,460 days in the Indiana Department of Correction, suspending all but time served. You'll get credit for time served and spend the remaining time on formal probation. Complete the CDA program before release, which you've done. Undergo substance abuse treatment, IOP aftercare as a condition of formal probation. Be responsible for the payment of all associated fees. Sign all releases of information for court, probation, state, and council. There's a drug abuse prosecution, interdiction, and correction fee of $200. Looks like there's credit time, 216 days. That goes from November 12th, 2025 through June 15th, 2026. And then I guess I don't understand. So he's only serving that in custody time, the 216 that he's going to be released today?
That's our understanding.
Yes,
Okay.
Your Honor.
All right. So, Mr. Messer, there'll be fines, fees, and court costs. Was there a bond here? You'll be responsible for the payment of all your fines, fees, court costs, probation, initial administration fee, jail booking, sheriff's death benefit fee. Are you going back to work?
Well, don't currently have a job, but I will.
Okay. So I'll give you 6 months to pay all the fines, fees, and court costs, okay?
Thank you. Appreciate it.
All right. I need you to go from here to the probation department at 157 Franklin Street and get started with your probation. Do you know where they're located?
I'll have whoever picks me up, pull it up on Google.
157 Franklin, sir. Good luck to you.
Yep, thank you.
Donald Samuelson, state, would you please set a record?
This will be State of Indiana versus Donald Samuelson, 64D01, 2312 F5 11797, 604001, 2405 F3 5160, 604001, 2406 F6 6144. Defendant appears in custody by video at the Porter County Jail and is represented by counsel, Attorney Patton, in the courtroom. State is represented by Deputy Prosecutor Hammer. We were set for sentencing.
Anything on the pre-sentence report?
No, Your Honor.
Mr. Patton?
Your Honor, I reviewed it and delivered it to Donald last week. Donald, have you reviewed the document? Do you have any corrections to it?
No, I don't. I looked over and it's good.
I do see the PAC program sent us a letter. So that's good.
Your Honor, he is eligible, as indicated on that letter, and I've been informed by the jail case manager that he has a bed reserved for him at Respite House.
Is that right, Mr. Samuelson? You going to respite?
Yeah, the caseworker here is going to take me over there if you accept my plea today, straight from here.
All right. Mr. Hammer, argument or evidence?
Just argument, Your Honor.
Go ahead.
Your Honor, I would ask that you accept this. He has spent 578 actual days in the Porter County Jail, done the CDA program, has done a significant amount of programming. He's going to be having to get out at some point, and I believe this transition to their respite house and 2.5 is the best way to do it, Your Honor.
Okay. Mr. Patton?
Your Honor, we would join in that request. You'll see the gap in his time of incarceration. He resolved a Lake County matter in the interim to make him eligible for these programs, and we would ask you accept the plea.
Thank you. Mr. Samuelson, this is your chance to say whatever you might like to say before I rule on the case. Would you like to exercise that right, sir?
Yes, Judge. First, I'd like to say I'm sorry for my actions that led me here. Then I would like to shine some light on the things I've done while I was in jail. I've gotten my GED, completed TC program twice, and gotten over 40 certificates through the Adobo program. Then I take it upon myself to get a bed at the halfway house. I'm just asking the court to accept my plea so I get back to my family and use the tools here that I've gained in my everyday life. Thank you.
Thank you, Mr. Samuelson. We'll accept your apology for our part. I think, though, that in situations like this, you've got to apologize to yourself a little bit and start working that whatever program you're on to start making amends to the people that you've heard outside and, different things like that. It sounds like you're probably a little bit far along in the process. In any event, I do appreciate your words, and I hope that you hold yourself to them. I will accept the recommendation of plea negotiation. Pursuant to that, enter judgment of conviction on a lesser included count 1 dealing methamphetamine, a level 4 felony, dismissing all remaining in the remaining causes, dismissing all in F6 6144 and in F5 11797. Sentence you on F3 5160, count 1 to 6 years in the Indiana Department of Corrections, suspending all but time served. Credit to be served on 2.5 day reporting with formal probation. You'll be ordered to complete the Porter County Jail Chemical Dependency and Addiction Program and Therapeutic Community before release, which I understand you've already done. You'll undergo substance abuse treatment, IOP aftercare as condition of day reporting with formal probation. You'll be responsible for payment of all associated fees. Sign out releases of information for the court, probation, state, and council. You'll reimburse the Porter County Narcotics Unit $100. You'll pay the criminal offense mandatory fee, which is a $200 drug abuse prosecution, interdiction, and correction fee. Looks like there are 578 actual days from May 16th, 2024 through May 22nd of 2025, and then November 22nd, 2025 through June 15th, 2026. You'll get Class B credit for those. Like I mentioned, I've got the 2.5 day reporting letter. They understand what's required of you in that program. And I think I already mentioned you completed CDA and therapy community. This sentence has to be consecutive to that of Lake County case 45 D07 2304 F6 794. There was a cash bond posted in F5 11797. From the cash bond, the court will retain court cost, probation, initial and administration fee, jail booking, and sheriff's death benefit fee. Let me figure out where it goes. Ah, Jessica Staton.
I'm guessing.
Hi. Sheriff.
We might want to put that in the. I thought that Carrie.
I think she's still in custody. Oh, you know, does she still live on May Street in Portage when she's not in rehab or in jail?
I haven't talked to her sick for a long time. I have no idea what she did. I think so.
We'll send that to her 2847 May Street address in Portage, 46368, and see what happens. We'll get it back. We have to figure out something. Yeah, you can take the criminal offense mandatory fee out of there and the $100. Yeah, take it all out of there. Yeah. Okay, Mr. Samuelson. Like I say, I wish you the best of luck. I think that a step down program like this, firstly, I commend you for all the work that you did while you're in jail, right? Getting your GED, that's a huge thing for you to be able to get back into society and to try to get a job. You're going to need that GED. There's no question about that. All the other work you did in Porter County Jail and your sobriety. You mentioned having a toolkit, a toolbox, things that you're able to use now when you're out there in the community. This kind of a step down program really facilitates that for you. I find that it's really easy for people to maintain their sobriety in the jail, even though, you know, occasionally some things slip through. But usually it's really easy for you in that kind of a structured environment. Now, when you're jumping out into the public, all the things that are triggers for you are available to you again. All right. So you have to learn how to deal with those. And being on a 2.5 and being in the respite house give you that kind of structured environment that will facilitate or allow you to be able to deal with those triggers a little bit more effectively and then step you out into the community after the end of your probation term. So I really hope that you have what you need to be able to make it work. And I really hope that you have the support structure and the people that you need to rely on in case things get a little bumpy, a little hairy along the way, because things will get dicey, right? You
Yeah.
gotta be prepared for that. All right? So
Yeah.
best of luck to you. Need you to go from here to the probation department, get started on the terms of your probation. You're going to go from there to the PACT office and get started on the 2.5 day reporting program right away. Do all that today, please.
Okay.
And
Just to clarify, Donald, do you know how you're getting to respite house?
yeah, he's
I'm not-
getting a ride from the case manager.
I just wanted to confirm that, and I didn't know if that needed to be in the
Yeah,
order.
yeah, case manager's taking me over there, and then I'll just get a hold of probation or however the respite, I don't know how they do it, if I can leave and go to probation, right? I mean, you're ordering me to go there, so I have to go there right away, right?
Are you in respite 1 or 2?
Respite 2.
So good for you, because the beautiful day outside, that's an easy walk from respite 2 down here to the probation department and then over to the PACT office, okay?
Okay,
So you can take that Shoe Leather Express and get around all the places you need to go today, okay?
yep, thank you, Judge.
All right, we're adjourned. Good luck. Oh. Oh, okay. You're on Window Web?
I don't believe so.
I think that's Fleming.
Let me look.
By AM, we don't have the file because
Looks like he's in the CDA program. Did you graduate from CDA yet, Wendell?
Yes, I graduated July 1st.
You did?
Yeah, July 1st I graduated. I got like 3 more weeks.
Yeah, I got your appearance back on March 17th, and then he's been in CDA.
Your Honor,
Looks like we had a hearing on April 6th, and we just bumped it over to today to give him time to finish up that program.
Your Honor, if we could just bump this out 2 weeks to the 29th, right before. I apologize. My staff must not pull the file when they saw Mr. Fleming's name on the court call.
Okay. Okay. Well, we can do an admission right now.
I'd rather have the file in front of me if we could put this on the 29th, if he's graduating on the 1st.
He graduated on the 1st.
Oh, I thought he
July
said.
1st.
Oh, you graduate on July 1st.
Yes, sir.
That changes the entire dynamic. Thank you. I heard June 1st. We'll set you up for July the 6th at 9 a.m. We'll have you back July the 6th at 9. And I don't think I can make it out for July the 1st, but I'll try. Things are pretty interesting that morning. It's on my calendar. All right, Mr. Webb, we'll see you back here on July the 6th at 9 a.m. You're ordered to appear.
All right, thank you very much, Joe.
Good day. Sorry, I thought he was done with it and he was going to sit for another 2 weeks.
Have a good day, Your Honor.
Thank you, sir. You too. Latrell Adkins, state, would you please set a record?
This will be State of Indiana versus Latrell Adkins, 64 D01 2507 F5 7389. Defendant appears by video and is represented by counsel attorney Patton in the courtroom. State's represented by Deputy Prosecutor Hammer. We're set for status.
Mr. Atkins, did you have permission to appear by Zoom this morning? Mr. Atkins, can you hear us okay? You need to unmute your mic, sir.
Your Honor, it appears that he did the last time he was appeared by video.
Good morning.
Can you hear us okay, sir?
Yeah.
Okay, did you have permission to appear by Zoom today?
They told me to write on our call for the permission. He told me to write a letter this Friday. So I wrote the letter and I sent it out on Friday. So when I called this morning, she said it would be no way that it would have been by now.
I can barely hear you, sir. What's important is that you try to speak into the microphone for your telephone. Or if you're using a computer, make sure you're speaking into the microphone because it's difficult to hear you. What I heard was that you sent a letter in, that you sent it on Friday, and that you called in this morning to get the Zoom information. I don't see anything that demonstrates that you'd have permission to appear by Zoom, and you're in Gary, okay? Sending a letter on a Friday before your hearing, or day before your hearing, essentially, is, pretty disingenuous. There's no way it's going to get here in time. Mail can take up to a week now. So normally I would issue a bench warrant for your arrest at this time. But because you've appeared by Zoom and we have you here now, and I'm able to explain these things to you, I'm going to let the case proceed. Let's figure out what your counsel wants to do next. Sir?
Your Honor, if we could just have a further status date, whenever you want to set it. I need to speak with him too, and would ask Mr. Atkins to contact my office so we can discuss how we're going to proceed with this case.
And Mr. Atkins, I need for you to call your lawyer today, right after your, he's going to be back in his office by like 11. or call over there and get
I'm still going to be here, Your Honor. I'm covering for Mr. Shargaloff to submit a plea at 11, and then we have Mr. Allegretti at 11:30.
call there right now and get on his calendar so you can talk with him, make a phone appointment at his office so you can get to work on this case. I'm going to set you over for July the 13th at 9 a.m. You still live in Gary?
Yes.
Yeah, you can't appear by Zoom, sir. You have to come here in person. All right?
Okay.
Okay, so we'll see you on July the 13th. Call your lawyer today, get on his calendar, get this case worked out, because we're going to be at over a year on the next hearing date, and I'm going to start barking about getting this case set for trial. Okay? So let's get it done.
Okay.
We're adjourned. Darmario Johnson, state, would you please set a record?
State of Indiana versus Damario Johnson, 64D01, 2509F3, 10120, and 64D01, 2509 CM10254. Defendant appears with counsel attorney Patton, states represented by Deputy Prosecutor Hammer. We were set today for status.
You all right?
Yeah.
Yes, sir. How can I help?
Your Honor, as you can see, Mr. Johnson appears out of custody. He recently posted bond. I believe it was an $8,000 cash bond, and would request that the appointment of the public defender be reviewed at this time.
Okay, let me see. Looks like Ms. Pearlie Johnson posted the bond for him. Who's Ms. Johnson? Pearlie? Okay. Is she interested in signing that bond over to a lawyer so a non-public defender lawyer could represent you? Private attorney? Okay, can you take the mic so that we can actually pick you up?
Not yet. I don't believe so.
Okay. Sir, please raise your hand to be sworn. Do you swear affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes.
Okay, thank you. Are you going to work while you're outside?
Yeah. I was gonna ask for more time to find a job so I can pay back my grandmother.
Okay. What kind of work you plan to do?
Co-operator, forklift. Yeah.
Okay.
Yeah.
Where would that be?
Hopefully somewhere in Portage or somewhere close near me right now, because right now we don't have really transportation like that.
Have they told you how much you'll earn at that job?
17 to 16 an hour.
But you haven't started yet?
No, I haven't started yet. I had got the paperwork for Tosca, but they waiting for a position to be available so I can start work. And that was, I believe, Thursday or Friday.
Okay. So I'll maintain the appointment of the Porter County Public Defender Service at this time.
If we could have a status in 60 days, Your Honor, and I just need to have Mr. Johnson. He hasn't contacted my office since he bonded out. I need his address and contact information.
Let's go on August the 17th. Any objection, state, to the continuance?
No.
Okay. We are nearing the year mark on this case as well. Not until September, but that'll put us closer. August 17th at 9 a.m. You're ordered to appear back here August 17th at 9. Are you staying in Gary as well?
Yeah.
Okay, we'll see you in person then.
Is it the 4616 Miller?
16.
Okay. Yeah, what's your number?
777 1920.
You have email?
While they're taking notes, let's set our record for Kiera Smallwood.
This will be State of Indiana versus Kiera Smallwood, 64D01, 2502F5, 2256, and 64D01, 2502F6, 1881. Defendant fails to appear as there is still an active warrant. Defendant is represented by Attorney Patton, state's represented by Deputy Prosecutor Hammer. We're set for trial readiness and status.
So Ms. Smallwood had a approval to appear by Zoom. I don't see her on the Zoom.
Your Honor, it's my understanding that she is riding the circuit, if you will, between St. Joseph County Jail and Madison County Jail. And I'm not sure where she is currently, but I believe she has active cases in both of those counties.
These warrants are out of, I think that's Madison?
Madison.
Madison? Okay, I thought it was
A-
Hancock.
Anderson is the county seat, but Madison County.
Okay. Interesting.
The last information I had was a month ago from her boyfriend, who indicated that she was in the St. Joseph County Jail awaiting transfer to Madison County Jail. It's my understanding she wants to submit the plea that's been presented. So based on that fact and the fact that she's not here, I would request that the pretrial conference set at the end of July and the jury trial setting be vacated, and we just await her completion of her other matters until we can get her up here.
State?
Your Honor, I'm okay with that as far as the courts. Since I trust the representations made by counsel that he's intending on accepting the plea, I don't see why to keep that one on our schedule, because I think we're already double booked that day anyway.
Okay. All right, I'll grant that. Vacate all pending dates. We'll catch up with those small when we have her in custody. I don't have a warrant out for her.
I don't believe there is one in our court. I believe at the last hearing on March 2nd, she did appear via Zoom and was not in custody on any cases. But I believe since that time, she was charged in one or more other jurisdictions.
Okay,
She
I'll
was
take the jury trial, but I'm gonna maintain the July 27th pretrial conference. And she's either gonna be transported here for that, or she's gonna be appearing by Zoom from wherever she is.
I'll try to track down which jail she's at and communicate with officers there to give them the Zoom link.
Yeah, and I'll get her transported if necessary. So we can bring her up here and have her take care of this matter. Okay?
Thank you.
All right. Rodrigo Gonzalez Velasquez. State, would you please set a record?
This will be State of Indiana versus Rodrigo Gonzalez Velasquez, 64 D01 2512 F4 13255. Defendant fails to appear. However, is represented by counsel, Attorney Patton, State's represented by Deputy Prosecutor Hammer. We were set today for status. State would be requesting a bench warrant. He was advised the last time we were here through the use of an interpreter of today's court date.
Did he contact you, Mr. Patton?
He has never contacted my office. The only conversations I've had with him have been in person at the courthouse. I do believe there's a surety bond.
There it is. He's also on pretrial. I haven't heard from the pretrial office. Yeah, I'll grant the motion. We'll issue a bench warrant for his arrest. And I will ask staff to forward this to the pretrial services office, and I'll order them to provide me an update about his contacts with their office. And we'll see what's what. Jimmy Davis Jr., State, would you please set a record?
This will be State of Indiana versus Jimmy Davis Jr., 64 D01 2507 F5 7934. Defendant appears with counsel Attorney Patton, State's represented by Deputy Prosecutor Hammer. We were set today for sentencing.
Anything on the pre-sentence report, Mr. Deputy?
No, Your Honor.
Mr. Patton?
Your Honor, we have no corrections to the document.
evidence or argument for sentencing, Mr. Hammer?
Your Honor, with the facts that are given here, and he did spend 32 actual days in credit, state would be asking that you accept the plea as is.
Mr. Patton?
Your Honor, we would join in that correct request and just note that he does live in Manteno, Illinois, so there would be that transfer.
Did you have $355 on you today?
Not currently, sir.
Do you still want me to accept this plea today or sentence him on this today? You got to stay in Indiana till you come up with $355. You realize that?
Yeah, you can get the money.
I can get it.
You can get it today?
I got a job now.
Can you go to the ATM and withdraw it?
Cash and check, get 300.
Okay.
I can get 300 today.
300 is not going to do it. You need $355 to be able to leave the state of Indiana today if I'm going to transfer your probation to Illinois. That's the rule. Otherwise, you have to figure out how to stay here,
Your Honor, if we
or I could continue this case.
Your Honor, if we could continue this for 2 weeks,
Yeah,
the 29th.
On defense motion, I'll set you over until June 29th at 9 a.m. You're ordered to appear back here June 29th at 9. Make clear your understanding that you need $355 in cash or some sort of fund that they'll accept downstairs so that you can pay what you need to pay to be able to transfer your probation. All right? We'll see you back here in 2 weeks. We're adjourned.
Your Honor, you said he did have a cash bond partially, right? Or he did have it was cash and surety, correct?
I don't know.
Okay,
You talking about Jimmy Davis Jr.?
yes. Because probation was saying he can use part of that 355 can come out of the bond.
No, it can't.
Oh, it can't. Oh,
They can't process it fast enough for it to
Oh.
make any difference.
gotcha.
Yeah. I could release it now and they may be able to process it in time.
Okay.
If that's what Jimmy's talking about.
If that's a possibility, Your Honor, we would request the 355 or whatever the amount needed.
He's got 1,000 cash. I'll authorize the probation department to release 355. I'm sorry. I'll authorize the clerk's office to release $355 in cash to the probation department for payment of the fee, but we still need 2 weeks to process it.
Understood.
So I'll see you back in 2 weeks. Okay? Make sense? Okay. Hopefully they can get it done. Yeah, we'll add whatever inspiration we can add down there. You too, sir. Is that all you have, Mr. Patton?
No, I'll be back in an hour.
All right. I'll be awaiting your return. I know, look at that thing. You're Mr. Seville, right?
Yes, sir.
You've been sitting there for a minute? Cesar Ratio, state, would you please set a record?
State of Indiana versus Cesar Ratio 64D0 12510 F5 11682. Defendant appears with counsel attorney Seville, states represented by Deputy Prosecutor Hammer. We were set today for a status, Your Honor.
Yes, sir.
Yes, Your Honor. We had previously had a deposition with a third-party witness. I know the state had said that they needed some time to discuss that matter. I don't know. I know that their trial schedule is somewhat busy. I don't know if they've had an opportunity to do that yet or not.
I have, but I want to just briefly talk to you and then we can, now that I've had that.
In that case, Your Honor, if we could set this over for 30 days.
Just make sure if you can just reach out, like, probably not email, but get on my actual schedule and then we can talk.
Does the 13th work for you?
Yes, Your Honor.
July 13th at 10 a.m.?
Yes, Your Honor.
All right, sir. On defense motion, we'll set your case over to July the 13th at 10 a.m. In order to appear back here July the 13th at 10. Delays charged to the defendant. Do you have any questions?
No, sir.
We're adjourned.
Thank you, Your Honor.
Good day, sir. Mr. Barnes, you have a matter for Kaylee Schonenberger. State, would you please set a record?
Yes, this will be State of Indiana versus Kaylee Schoenberger, 64D01 2304 F1 3701. Defendant appeared with counsel Attorney Barnes, states represented by Deputy Prosecutor Hammer. We're set for sentencing.
Judge, moving to sentencing of what date?
Grounds?
We are awaiting co-defendants.
13th will get you there.
So
Any problem, state?
Let me check. When is looking, Hardy's sentencing is July 1st. So yes.
All right. On defense motion, we'll set you over to July the 13th at 10 a.m. You're to appear back here July the 13th at 10. Do you have any questions? We'll charge the defendant, although that doesn't really matter. Yeah.
thank you, Judge.
All right. Thanks.
Have a good week.
You too. Thanks. Is that all you had, Mr. Barnes?
It is.
Good day, sir. Mr. Vogel, you've got Fernandez Sanchez Alvarez. State, would you please set a record?
This will be State of Indiana versus Fernandez Sanchez Alvarez, 64D01 2410 F510230. Defendant is present with counsel, Attorney Boga, states represented by Deputy Prosecutor Hammer. We were set today for status.
Yes, sir. Good morning, sir.
Morning, Judge.
Thank you for your kind service while I was away on business.
Not a problem at all. It's my pleasure.
Well, I think they worked you like a pack mule. So,
You did.
yeah.
Yes. Yeah.
Yeah, I appreciate your help.
I tried to speed things along and still keep it, within the constitutional framework.
You got to keep it lively,
Yeah.
for sure. Yeah.
Judge, on this matter, I've been speaking to Mr. Hammer. I am not the first counsel on the case, and that's one of the reasons why, if the court looks to 24 filing, since I have been in, I've been active with Mr. Hammer in trying to get something resolved. We're looking at drug court, Judge. There was one issue out in Lake County that Mr. Hammer and I had to look into before we could take any additional steps in that process. I have information from Mr. Hammer. I'm not sure when my next meeting with him is, but it's clearly gearing towards a non-trial resolution. If that makes any difference, of course, I will take any 4C time.
How much time do you want?
Okay with whatever works for your schedule.
Judge, that's the same with me. I'm going to be out of town towards the end of this month, but I wouldn't be thinking we'd get a 30-day continuance. Hopefully, maybe something along the.
About July 20th.
That'll be perfect.
Does it work?
Yes.
Okay. Yeah, she doesn't have much criminal history.
No.
No.
Yeah. So I don't even know about drug court. But in any event, I'll let you all work that out. July the 20th on defense motion at 10 a.m. We'll have you back here July the 20th at 10 a.m. in order to appear back here at that date and time. Do you have any questions?
No.
Okay, we'll see you then. Mr. Woodward, what do you have?
Mr. Iglesias, however, I think he's on his way.
Okay. Yeah, I don't know yet. Mr. Cantrell, you've got Norman Richardson. State, would you please set a record?
State of Indiana versus Norman Richardson, 604001 2308 F2 7029. Defendant is present with counsel. Attorney Cantrell, states represented by Deputy Prosecutor Hammer. We were set today with the bench warrant under advisement, and we're set for a pretrial.
Okay, good morning, sir.
Good morning, Your Honor. How are you, sir?
I'm good, sir. And you?
Good. Mr. Hammer and I are trying to resolve this case. We got a trial coming up. I believe it's on the July 21st and 22nd. It's listed for a 2-day trial, I believe. And we're asking to affirm that, but I am asking for a final pretrial conference sometime between now and that trial setting, Your Honor. I'm hoping to have a resolution. I'm still working on one, sir.
Well, we're going to try this case. I see that now, for sure. And you want something between now and then?
Yes, sir, because I'm still trying to resolve it short of the trial.
I can go on July the 6th.
That's good. I don't ever get to do anything fun, so I'm not going anywhere, so it's all good.
Okay. You should be, your ears should be stopped ringing by then, maybe from all the fireworks and such.
Hopefully.
On defense motion, we'll set you over to July the 6th at 10, correct?
Yes, sir.
At 10 a.m., you're ordered to appear back here July the 6th at 10. We'll see you then.
Right.
Okay, we're adjourned. Thank you.
Okay. Come in.
Mr. Elwood, you have Christopher Bachnet. Stay, would you please set a record?
This will be State of Indiana versus Christopher Bachnet, 64 D01 2604 F5 3746. Defendant is present with Council Attorney Elwood. State's represented by Deputy Prosecutor Hammer. We were set for omnibus today with a pretrial on July 20th.
Yes, sir.
Good morning, Judge.
Good morning, sir.
We could affirm that July 20th pretrial.
Yeah, Mr. Bachnet, I already had you set up on July the 20th at 10 a.m. I'm just going to affirm that date at this time in order to appear back here as you were previously ordered on July the 20th at 10.
Yes, sir.
Okay, we're adjourned. Thank you.
Thank you, sir.
And then for Michael Martinez, Dave, would you please set a record?
Yes, this will be State of Indiana versus Michael Martinez, 64 D01 2601 F2 260. Defendant appears with Council Attorney Elwood. State's represented by Deputy Prosecutor Hammer. We were also set for a status today, Your Honor.
Yes, sir. Mr. Elwood?
Judge, you previously reduced the defendant's bond and ordered him to complete programming. I have certificates of completion for the programming. He's cooperative with pretrial. I just met with them recently, so I would just ask for a new status date.
How much time are you looking for?
July 20th would be great.
10?
Yes, please.
Any objection, State?
No.
All right, sir. On defense motion, we'll set you over to July the 20th at 10 a.m. in order to appear back here July 20th at 10. Do you have any questions?
No, sir.
We'll see you then. We're adjourned. Place charge to the defendant.
Thank you, Judge.
Thank you, sir. You ready, Mr. Fetch?
I am, Judge.
Noah Fronek, State, would you please set a record?
State of Indiana versus Noah Fronek, 64 D01 2502 F4 2172. Defendant appears with Council Attorney Fetch. State's represented by Deputy Prosecutor Hammer. We were set today for status.
Morning, sir.
Morning, Judge. Judge, we need to get the depositions of two of the witnesses in this case scheduled. Mr. Hammer's schedule and my schedule has not lined up. Judge, could we go to an August date? And I think we should be able to get that accomplished by then.
I can do it on August 3rd, 17th.
Judge, if we could do the 17th, that would be great.
You want it at 10?
We could do 10 o'clock again, please.
Yeah, this will be our last continuance and I'm going to set it for trial.
Understood, Judge.
All right. August 17th at 10 a.m. on defense motion. We'll set you over to August the 17th at 10 in order to appear back here at that date and time. Delays charge to the defendant. And if we don't have a resolution that day, I'm setting this case for trial.
Very good.
All right.
Thank you, Your Honor.
Thank you, sir. William Lundy III. State, would you please set a record?
On the record for State of Indiana versus William Lundy III, cause number 64 D01 2506 F5 7148. Defendant is present with his attorney, Attorney Matt Fetch. State's represented by Chief Deputy Armando Salinas. We're here for a status.
Yes, sir.
Morning again, Judge.
Yes, sir.
There was a report, discovery, State Board of Accounts report that was provided here in the last week or two. The state extended an offer last week. So if we could respectfully have that same August 17th date, I think that we should be in a position to resolve the matter at that time.
Any objection, State?
No objection, Judge.
August 17th at 10 a.m., sir, on defense motion. I'll set your matter over to August 17th at 10. Your order to appear back here at that date and time. The delays charged to the defendant. We'll see you then.
Judge, thank you.
Thank you, sir. Have a great week.
You too.
All right, guys. I gotta get my daughter to work, so we are ending it now. Thank you so much for coming out today, guys. I really appreciate it. Sorry about the earlier struggles, but hopefully tomorrow morning goes better, right? Saturday morning. I hate that my voice is on in the background. It's distracting me. Guys, I will see you in 22 hours. I hope you guys have a great day. I hope you guys end the week with a bang. And I'll see you again soon. Thank you. Bye, guys.
song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see